Hello everybody. Not everybody need to know everything in life, but there are some things which everybody should know, be it big or small, rich or poor, teacher or student. About one such thing we are going to see in this video. Textbooks in India usually treat these, that is the central government and the state government, as two separate entities or in two separate lessons. Won't it be a challenge to present them on the same table? Secondly, explanation for terms such as these are very sparse in our textbooks. They literally require a large amount of research for one to understand them better. The social teacher wanted to save you the trouble of going through all this, and hence this video. After all, one of the essential qualities of a good citizen is that he be aware of the polity of his country. Isn't it? If you like this video, then hit the like button, share and subscribe. Come, let us go on a tour to the museum. When man began to populate the earth, he was few in number. The strongest led the group to hunt and to survive. Later, when he began to live in temporary shelters, he formed clans. The clan leader protected the clan from harm. As man began to settle along river banks, their population grew. The clan leader became king. The king fought wars and ruled his people. With the growth in numbers, the multitude needed some sort of order, something with what they can be governed with. That's something we call governance. Depending upon their imagination or necessity, this governance has taken shape into many forms. Here we stick to one type, recognized the world over as their best: democracy. Democracy is a type of governance where people gain prominence. The people are the actual masters. But since not everybody could do the actual ruling, they nominate a person to act on their behalf. Democracy first came into existence in ancient Greece some 2500 years before. Democracy is derived from the Greek word demos kratia, which means the power to rule belongs to the people. And it is of two types, one direct and another indirect democracy. When people select their leader directly by means of voting, such is called direct democracy. On the contrary, sometimes people don't select their leader directly. They only select representatives who in turn select their leader. Such is called indirect democracy, and countries with large population follow this type. In India, indirect democracy is followed. Some democracies around the world follow a federal type of government. What is a federal type of government? In India, we have a government which looks after the overall affairs of the whole country. We call it the central government, or more lately, it is referred to as the union government. We know that India consists of 29 states besides the various union territories. As in all the other states, in the state of Tamil Nadu, we have a government which looks after the affairs of the state and is called the state government. So, when two types of government function in a country simultaneously, we call it as a federal setup. Now, let us see the two types of governments. The state government first. It has three organs: the executive, the legislature and the judiciary. Under these headings, we see various subdivisions which make up these organs. The same structure we can see in the central government too, though the names under these headings vary, but they work in the same manner. Our objective here is to compare the two and identify their similarities and dissimilarities. But first we need to understand how these organs work. I will present three scenarios. In the first, what do you see? Medicines, wood and cars being manufactured in factories. Where would they go from here? Of course, the medicines go to the pharmacy, the cars to the showrooms, and the wood go to make houses, furniture, etc. Products thus manufactured are put to sale or use. Who judges whether the quality is good, the price is reasonable or not? Yes, the customers. This same process can be noticed between the three organs of the government too. The legislature manufactures the laws of the nation. The manufactured laws are then put to sale or here executed or implemented by the executive. And whether the laws are good or bad is judged by the judiciary. The legislature. We will get to understand the parliament and the legislative assembly. Where is the parliament and the state assembly? Seat of government. The Indian Parliament is situated in New Delhi, the country's capital. And the Legislative Assembly for the state of Tamil Nadu is located at Chennai. The assemblies of other states too are located in their respective capitals. For Kerala, Trivandrum, Karnataka, Bangalore and Andhra Pradesh it is Hyderabad. First, we will get to understand the Indian Parliament. The parliament actually consists of three parts. They are the President, the Rajya Sabha and the Lok Sabha. The Rajya Sabha. The Rajya Sabha is chaired by the Vice President. And it consists of 250 members, of which 238 are elected from the states and the union territories. And 12 persons of eminence, that is people who excelled in the field of art, literature and sports etc. are nominated by the President. The Lok Sabha, it is the popular house of the Indian Parliament. And it is chaired by the Speaker who is elected from among its own members. The Constitution of India stipulates the strength of the Lok Sabha to not more than 552, but as of now it has 543 members who are elected by the people through elections, and the President nominates 2 members belonging to the Anglo-Indian community. Qualification of its members. A member of the Rajya Sabha or the Lok Sabha should be a citizen of our country. One should be 30 years of age to enter the Rajya Sabha, and for Lok Sabha it is 25. They should be mentally sound and economically solvent. Should not be in any other job in the government. A small comparison between the Rajya Sabha and the Lok Sabha. Lok Sabha is called House of Peoples and the Rajya Sabha Council of States. Members of Lok Sabha are elected by the people. Maximum of 552 members can be elected, but at present there are 543. And 2 members are nominated by the President and they stay in house for a period of 5 years. Whereas the members of the Rajya Sabha are elected by indirect elections. Maximum members 250, 12 members nominated by the President. And they hold office for 6 years. Term of the House. You very well know that the members of the Rajya Sabha stay for a period of 6 years. But the thing is that they all don't get elected or don't get retired at the same time. How is that? Okay, I will tell you how. Every 2 years, 1/3 members retire from the House while 2/3 remain. After another 2 years, the next 1/3 members retire. Every time members get retired, new members are elected in their place. For example, if a 1/3 member retire in 2024, the next 1/3 will retire in 2026 and the last 1/3 in 2028. So, at any point of time, there are at least 2/3 members in the House, and so it is aptly called as a permanent House. On the contrary, the Lok Sabha, which houses 545 members, get totally dissolved at the end of its 5-year term, and new members are elected for the next 5 years. Next, we will see how Rajya Sabha works. The Rajya Sabha is modeled on the lines of the House of Lords in the United Kingdom. Consisting of 250 members, 238 members are elected from the various states. And Tamil Nadu is allocated a quota of 18 seats, Kerala 9 seats, Sikkim, a very small state, is allocated only 1 seat. Elected members from all the states and union territories make up the Rajya Sabha. How and where elections to Rajya Sabha held? Members to the Rajya Sabha are selected not in the Rajya Sabha, but actually they are selected on the floor of the legislative assemblies of the various states, and the selected members are then sent to the Rajya Sabha. Members of Rajya Sabha are elected in accordance with the system of proportional representation by means of single transferable vote. Can you make anything out of it? Hardly could I. Let's take for instance the case of Tamil Nadu. The major parties in the state assembly share the allocated Rajya Sabha seats among them. How it is done? Of course, through elections. Members of the state assembly cast their votes to elect their representatives to the Rajya Sabha. How about votes polled in the Rajya Sabha? The electors, that is the members of the legislative assemblies, are given a list of candidates to choose from. They would be provided with a violet sketch pen to mark with. Marking with any other pen is not allowed. And they rank their candidates according to preferences. These preferences range from 1 to 10. The most preferred candidate gets the first rank or first preference. After marking in secrecy, they show their ballot paper to an agent of the House before casting their vote. This system of voting is called an open ballot, and it was introduced during the Vajpayee government. How are votes counted? The votes that the various candidates receive may be tabulated like this. Let's take the first ballot. The first voter has shown his preference by ranking the I candidate as 1. And candidate I gets his first vote. Voter 2 has given his first preference to shark candidate. The third voter, to whom does he give his first preference? The I candidate again. In this way, the candidates keep getting more votes. Usually in elections, candidates who get the most number of votes are declared winners. But in a single transferable vote system, when candidates get a certain number of votes or reach a limit called the preferential quota, they are immediately declared winners. How they derive the quota, we needn't bother here. And votes received over the quota, that is the excess vote, is transferred to the next preferential candidate. So, whom does the third voter prefer next? Well, it's the balloon candidate. Balloon gets the excess vote, but with a lesser value, of course. In this way, candidates who reach the preferential quota will get selected and they will be removed from further counting. Now, let's see the fourth voter. His first preferred candidate, the I, has already reached the quota. His second preferred candidate, the microphone 2, has reached the quota. So, we move to his next choice. And vote from the fourth voter goes to the balloon candidate. This process will continue till the required number of candidates are selected. Though a sophisticated process, in the single transferable vote system, unlike in the normal vote counting methods, Votes never get wasted, as no one candidate can garner all the votes to himself. Secondly, the excess vote move to the next preferred candidate, and so votes don't get wasted. Wonderful, isn't it? Thus, parties who contest take their share of the allotted number of seats and represent their state in the Rajya Sabha. Another common terminology that needs explanation is universal adult franchise. Universal means everybody without any distinction. Adult refers to all persons above 18 years of age. Franchise means right to. Here it is right to vote, without any distinction of religion, culture, or creed. This universal adult franchise is synonymous with universal adult suffrage. Only that suffrage is an old term, that's all. All this time we were getting to know about the legislature in the central government. The legislature of the state government is very similar to that of the central government, with only some minor differences. The legislative council can be compared to the Rajya Sabha and the legislative assembly to the Lok Sabha. We will see about the legislative council first. Elections to the legislative council. The legislative council is the upper house of the state legislature, whose total strength cannot be more than one-third the strength of the legislative assembly and not lesser than 40. They stay in the house for a period of 6 years, just like in the Rajya Sabha. For example, if the total number of MLAs in the Tamil Nadu Assembly is 234, one-third will be equal to 78. But as a matter of fact, the Legislative Council in Tamil Nadu was abolished in 1986 for reasons that are chiefly financial, and of course there are provisions for doing so. Well, who selects these members? The Constitution of India envisages the local bodies to select one-third of the MLCs, the graduates of the various universities in the state to select 1/12 members. Again, 1/12 of the members are selected by the graduate teachers in the state. One-third of the members are selected by the members of the Tamil Nadu Legislative Assembly, that is the MLAs. 1/6 of MLCs will be nominated by the governor. Let us see an illustration. Next, the Legislative Assembly. The Speaker of the Legislative Assembly is elected from its own members, and his duty is to ensure the smooth functioning of the House. The Tamil Nadu Assembly, for instance, has 234 members, and one member from the Anglo-Indian community is nominated by the governor, and they stay in House for 5 years. Elections to the Legislative Assembly. Elections are held in the state, and the people of Tamil Nadu elect the members of the Legislative Assembly by following the universal adult franchise policy. Thus, they select the 234 MLAs of the state. The Constitution stipulates the strength of the Legislative Assembly to be not more than 500 and not lesser than 60. Depending upon the size of the state and size of the population, the number vary from state to state. Tamil Nadu has 234 from that many constituencies. How are constituencies demarcated? India as a whole is divided into numerous constituencies, and each of these constituencies are represented in the parliament by a member. The same can be noticed in Tamil Nadu too. For example, Tamil Nadu has 39 members of parliament, which means it has 39 parliamentary constituencies, one constituency for every district. And if it is for the assembly, Tamil Nadu will be divided into 234 constituencies. Coimbatore district has one parliamentary constituency and 10 assembly constituencies. Neighbouring Nilgiris, being a district, will have its own single parliamentary constituency and only 3 assembly constituencies. When we compare these two districts, Coimbatore having a high population is allocated more assembly constituencies. Nilgiris having less population, mainly due to its hilly terrain, has less number of constituencies when compared to Coimbatore. So, population is the benchmark. More population, more number of constituencies. Less population, less number of constituencies. This applies for all the states in India. The biggest state in India, Uttar Pradesh, has the highest number of parliamentary and assembly constituencies. Sikkim, a very small state, has one of the lowest. Next we will see how laws are made or passed. To become a law, it actually travels through 3 stages. First, it is a draft or a proposal. Next, it becomes a bill. And lastly, it transforms into a law. Let us see in detail how this all happens. As a first step, the minister or the ministry in the central government prepares a draft in consultation with the Prime Minister and other senior officials in his department. The prepared draft will then be published in the newspapers and other media and thus made known to the public for them to view and give their suggestions. Valid suggestions are then incorporated and the final draft is prepared. Second step is presenting in the legislature. The draft thus prepared, once presented or tabled in the parliament, or more exactly the Lok Sabha, it is referred to as a bill. Hectic discussions then take place on the floor of the house over the bill. At last it is put to vote. If a majority members vote in favor of the bill is said to have passed the house. Next, the bill is presented in the Rajya Sabha. Here too discussions and voting take place. And should it be passed in the Rajya Sabha, it will be sent to the President. The President, in consultation with the Prime Minister and other eminent advisors of his, endorses the bill and it becomes a law. Great, isn't it? So, there are 3 steps involved in making laws. They are 1. Preparing a draft, 2. Presenting the bill in the legislature, and lastly, getting the President's approval. This same procedure is followed in the state government too. Only that there the governor endorses before a bill becomes a law. Okay, till now we were getting acquainted with the legislatures of both the central and state governments. Now we will get to know about the executive. We've already seen that the executive organ of the government implements the laws passed by the legislature. Remember? First, a comparison between the president and the governor, the top executives in their respective governments. Their qualifications. See how similar their qualifications are. They both should be a citizen of India, about 35 years of age, and should not indulge in any profitable ventures. Powers and functions of the President vis-a-vis the Governor. The powers exercised by them are very similar, only that the President has diplomatic and military powers, whereas Governor has discretionary powers. First, we will compare the executive powers of the President and the Governor. The President appoints the Prime Minister and the Attorney General. The Governor appoints the Chief Minister and the Advocate General. The Chief Election Commissioner, the members of the Union Public Service Commission are appointed by the President. Their counterparts in the state are appointed by the Governor. The Governor himself is appointed by the President. The Governor in turn appoints the Vice Chancellors of the various universities in the state. Next, legislative powers. The President inaugurates the Parliament and the Governor inaugurates the State Assembly before every session. Bills passed in the Parliament becomes a law only after getting the consent of the President or the Governor in the case of state legislature. And only they have the right to dissolve the Parliament or the Assembly respectively before the expiry of its term. The President and the Governor have the power to nominate persons of eminence to the Parliament or the Assembly. Money bills cannot be tabled in the Parliament or the Assembly without the prior approval of the President and the Governor respectively. As far as financial powers are concerned, both the President and the Governor in their respective authority should give their consent to the annual budget, use the contingency fund which is at their disposal when the situation arises, constitute a finance commission when need be. Judicial powers. The Chief Justice of India, the judges of the Supreme Court, the Chief Justice of the High Courts present in various states in India are all appointed by the President and him only. But both the President and the Governor have the right to pardon or reprieve even death sentences. Emergency powers. These powers are given to the President in order to restore public order if it was seriously threatened. And they are national emergency, state emergency, and financial emergency. This financial emergency is imposed by the President if he is not satisfied with the financial stability or creditworthiness of our country. Diplomatic and military powers are solely with the President of India. It is he who appoints ambassadors, diplomats to various countries, etc. Any agreement or treaty made with other countries are made in the name of the President. Military powers. The President is the supreme commander of the armed forces. The Governor too has some powers which are exercised at his discretion, and it is named so. Next, we will compare the powers of the Prime Minister vis-a-vis the Chief Minister. Their powers and functions relating to the Council of Ministers. The Prime Minister recommends to the President the list of persons to be appointed as ministers. The Chief Minister recommends to the Governor. Besides allocating or shuffling of portfolios, the Prime Minister and the Chief Minister guides and controls the activities of ministers under them. Secondly, how the Prime Minister functions in relation to the President and the Chief Minister with the Governor, we will see. The Prime Minister acts as a link between the President and the Council Ministers and the Chief Minister between the Governor and Ministers. The Prime Minister and the Chief Minister should be in a position where they can convey to their heads, that is, the President and the Governor respectively, the decisions of the government and give them necessary advice regarding various appointments in their governments. Thirdly, powers and functions of the Prime Minister and the Chief Minister relating to Parliament and the state's legislature. advising the president or the governor regarding summoning of the house, announcing the government policies, introducing the bills in their houses, recommending dissolution of the parliament or the assembly to the president or the governor come under these powers. Lastly, we look into the Council of Ministers. But before that, we will see the structure of the council. In the central government, the Prime Minister leads the council. The small but informal body of senior ministers are the cabinet ministers. And they hold very important portfolios in his government. The second category of ministers in the council are the ministers of state. They are in charge of lesser ministries or department and participate in cabinet meetings only when called for. Let us see how they work. Take the example of a cabinet minister with defense portfolio. This defense minister will have many departments under him and each department headed by a minister of state. It is the responsibility of the cabinet minister to oversee the various ministers of state under him. There is another group of low-ranked ministers in the Council of Ministers called the deputy ministers. They assist either the cabinet minister or ministers of state. So, the Council of Ministers consists of the Prime Minister at the helm, the cabinet ministers, the ministers of state and the deputy ministers. One can observe the same pattern in the state government too. The chief minister leads the council with the cabinet consisting of a standing committee which is a permanent one and an ad hoc committee which convenes only when called for. The Council of Ministers. How big can it be? The Constitution of India restricts the number to be equal to 15% of the total strength of the House. Functions and powers of the Council of Ministers. The Council of Ministers, both at the centre and the state government, have more or less the same functions and powers. Formulating new policies and implementing them, deciding the legislative program of the House when it is in session, appointing the heads of various departments under them, that is the IAS, IRS, IPS, IFS, etc., supervising and coordinating the activities of their departments, finalizing the annual budget. Till now, we were getting to know about the executive. Now we will get to know about how the Indian judiciary works. We will compare the Supreme Court with the High Court. What does the judiciary do? We already seen that the judiciary acts as a sort of quality control manager or a referee in a match. We will see it in detail. But first, where is the Supreme Court or High Court located? The Supreme Court of India is located in New Delhi, the country's capital. Every state in India is provided with a High Court and one only. The High Court of Tamil Nadu is located in the state's capital and its branch is established in Madurai to cater to the judicial needs of the southern districts. Powers and functions of the Supreme Court vis-a-vis the High Court. Both have the original jurisdiction and appellate jurisdiction. While the Supreme Court is endowed with advisory jurisdiction and judicial review, the High Court has some special powers called writ jurisdiction besides supervisory powers. Now we will see what each of these mean. We are well aware that we go to court only when a dispute arises. Thus, when a case be brought directly to the Supreme Court or the High Court, at the first instance itself, that power of the court to hear such cases is called original jurisdiction. Example, disputes between states or between the government of India and a state, etc. In any dispute, for example, the judgment will always be in favor of one party. The party against whom the verdict was pronounced has the right to go for an appeal to a higher court. This power of the Supreme Court and the High Court to entertain such cases is called its appellate jurisdiction. Advisory jurisdiction. The Constitution of India confers on the President the power to get advice from the Supreme Court. Usually they are matters of public importance. Writ jurisdiction. A unique power that the High Courts of Bombay, Calcutta and Madras are endowed with is the power to order or command a government machinery to act promptly upon an issue where fundamental rights are infringed upon. They are called writs. We will see them in detail. Writs are of 5 types. They are habeas corpus, mandamus, prohibition, quo warranto and certiorari. Oh, I don't think I am helping you any bit. It is because most of these terms you see here are in Latin. First, habeas corpus. Let's see a simple example. There are 2 persons. One person goes missing. His companion files a habeas corpus writ in court. The Honorable Court takes up the writ and comes to his rescue and orders the concerned government machinery, the police or whoever it may be, to produce the detained person before the court. Mandamus. Say a person requests a government office or maybe even a court to show him certain documents that which is in their custody, but of no avail. So the person moves a higher court for relief. That superior court orders the government agency or the lower court against whom the petitioner has filed the writ to favor the petitioner by producing the requisite documents before the court. A person has taken up a government job. On an allegation that he has willfully falsified his documents to usurp or get the job, the court can intervene. Taking up the writ of quo warranto, the court can order the public servant to produce his credentials before court for scrutiny and further action. In another instance, a person thinks a lower court has mistakenly passed a judgment based on insufficient or falsified proof. So he vents his grievance by filing a certiorari writ in a higher court. The superior court pulls up the lower court and orders it to produce before it all the records in its custody regarding the said case for further review. When a person feels that a court has wrongly taken up a case which he believes is an act uncalled for, he can go file a writ with the higher court, pleading it to issue an order prohibiting the lower court. This power of a court to prohibit a lower court from proceeding further is called prohibition writ. For once, this all-encompassing power of the High Court in issuing writs seem to belittle the powerful Supreme Court, which can issue writs only when fundamental rights are infringed upon. Judicial review. It is an exceptional power enjoyed by the Supreme Court, where it can even review a law that is passed by the legislature and call for its removal should it think that the law is unconstitutional. Supervisory jurisdiction. A minor but essential power enjoyed by the high courts in the state is that they have all rights to supervise and regulate the functioning of the lower courts under their jurisdiction. A recap.